I want to welcome everybody to Farella's Wine Industry Education Series. We're still virtual. We look forward to the day soon when we'll see one another in person. I think that day will come soon. And today's presentation will focus on the new statewide general water discharge requirements for wineries, otherwise known as the Winery Order. I think many of you are already pretty familiar with that order, and we have a great program organized today to walk through some of the requirements, talk a little bit about both the technical issues and the legal issues. And then as well, we've identified some scenarios that I think will be helpful to also discuss. So I'm joined today for the presentation by my Farella colleague, John Ugai. And we're also really pleased to be joined by our friends and technical experts from GSI Environmental, Tim Simpson and Mehran Ebrahimi. It looks like we've got a great turnout, including many attendees from the California Wineries Monitoring Group. GSI and Tim and Mehran are closely involved with that monitoring group, which has actually been in existence since around 1993. So definitely old friends and cohorts, goes back quite a ways. So if you could go to the next slide, Mehran, that would be great, if you don't mind. So I've given a little bit of an overview. As Margaret said, we have a lot to cover. So we'll have a number of slides that we'll go through. We also have your questions. Many of the questions I think will be covered during the presentation. And then we'll save time for Q&A at the end of the presentation. Margaret will come back on, we'll shut off the recording, and we'll have an opportunity to have some back and forth about particular issues that either may not have been covered or that you have questions about or that just may need some further discussion. So I think with that, I will turn it over to GSI Environmental and Tim and Mehran to talk about the technical review of the Winery Order. Tim and Mehran?
Yeah, I'll start off. Thanks everybody for participating today. I'm sure many of you have reviewed the WDR, and there's a lot there. So without further ado, we're going to let Mehran walk us through the the specifics, and then we're going to close with some scenarios, some common scenarios that we see would be applicable to many of you on the phone. So Mehran.
Awesome. Thank you guys. Thanks Tim. Thanks Buzz, Margaret. Some of you may have already heard or seen some of these slides already from previous presentation. We've updated them based on recent discussions with the regional board and state board, and I've included a potential example of what the fee schedule might look like. The reason I say why it might look that way is because it's not yet adopted. So the general order, or this general WDR, was adopted by the state board in January of 2021. However, wineries still cannot yet actually file their notice of intent to comply with the order because the fee schedule has not yet been adopted. The fee schedule adoption hearing is expected to take place in July, and it would become effective sometime in late summer, late August or September, when you guys are in the middle of harvest and have more important things to be worrying about. So I'll go over the WDR, and again, these slides are intended to be general overview. We're not going to get into a lot of the nitty-gritty site-specific scenarios, but we'll leave time at the end for questions to maybe review some of those site-specific scenarios. But we'll provide a general overview and how this may apply to you, who it applies to, and what next steps you should be taking. So the order was adopted, but you still can't apply until late summer or late August, September. So I suggest using this time now to kind of get your ducks in a row, look at your system, identify your data gaps. What information do you know about the system? What information do you still need to know about the system so that you could be ready to apply for coverage under the order when the fee schedule is implemented? So again, these this general order, which throughout the presentation I'll use general order or WDR. This is separate from the general permit, which we often refer to as the Industrial General Permit for Stormwater Discharges, which is an NPDES permit for allowing stormwater discharge to a surface water. This general order, WDR, prohibits discharges to surface water. So when we're talking about land application, either through like an irrigation system or a subsurface disposal system, that land application must be applied in such a manner that you do not have discharges to a surface water, such as your local creek or stream or a river nearby. The WDR is specific for those winery waste to land for disposal or reuse. So processed water, including wash water, cooling water, juice or wine. Stormwater runoff is included in that, but it does not include distillery waste or domestic wastewater. So some of you who may be involved in a system that's a subsurface disposal system that has a commingled treatment of domestic wastewater and your winery process water, that type of system would need to be separated, or you need to coordinate with the regional board if it cannot be separated. And we'll talk about that scenario later on. But this order is specific to the waste from wineries, so not distillery waste or domestic wastewater. And it does also include those processed water solids, or processed solids such as pumice or lees or sludge. In the WDR, it's encouraged that you reuse those processed solids such as pumice for composting or use as a soil amendment. And there's limitations on how that can be applied as well. So there's about 3,600 wineries in California. Each one of these little red flags on the map indicates one of the wineries. It's expected that about 1,500 of them will be eligible for this general order. There's a little less than 600 right now that have a site-specific WDR or conditional waiver. And maybe a little less than 600 might be able to file as exempt. So if you do not have a site-specific WDR, you are the higher priority for enrolling under this order when it is able to do so. The regional board and state board will be implementing some outreach programs to help wineries file for coverage under the order, bring everyone up to speed, but it is expected to take some time. If you already have a WDR, then you should check your WDR and evaluate if it's expired. Right? If it's expired, then you may be required to file for coverage under the order. If it's not yet expired or does not have an expiration date, then the regional board may revisit your WDR soon. And the priority right now is those that are not yet covered, or some of those wineries, if you're located in Napa County, you're part of that Napa County program, the Memorandum of Understanding, which will be gradually phased out as more wineries file for coverage under the order. So the requirements under this WDR are broken into tiers, and the tiers are based on the volume of processed water generated per year. So the column in the middle is the range of processed water that would correlate to each tier. If you generate less than 10,000 gallons of processed water per year, you may be exempt. If you are an exempt facility, like a small boutique facility, and you generate less than 10,000 gallons, but you're in an area that's has high density of other wineries and it may pose a threat to groundwater, then the regional board may evaluate the situation and require that you file under Tier 1. Tier 1 facilities are those that generate between 10,000 and 30,000 gallons. And if you're in a highly dense populated area with a bunch of other wineries around you, and the regional board may, if the regional board determines that there may be a threat to groundwater, they may require the Tier 1 facilities to enroll as Tier 2. Tier 2 is between 30,000 gallons to 300,000 gallons per year. Tier 3 is 300,000 to a million. And then Tier 4 is 1 million gallons to 15 million gallons of processed water generated per year. If you generate more than 15 million gallons of processed water, then you need to coordinate with the regional board regarding site-specific WDR. The column on the right are estimates generated by the Wine Institute. So there's a pretty good rule of thumb for estimating the amount of processed water you generate with respect to cases of wine produced. It's my understanding that most folks know exactly or have a good idea as to the amount of cases of wine that they're producing, but not necessarily the amount of processed water that they're generating. So we've added the column on the right simply for reference, but this is not incorporated in the WDR. And when you're filing for coverage under the WDR, you need to know how much processed water you're generating or have a good way to estimate the amount of processed water you're generating per year. Now, moving forward, you'll need a flow meter. If you're in tier 1 or tier 2, you may be able to use an alternative accurate method, such as performing a water balance, correlating that with the amount of wine that you're generating and see if it is in line with sort of the expectation of processed water generated with respect to the amount of wine you're producing, and then also correlating that with your water usage and doing a water balance and seeing if that makes sense.
Real quick, just to reiterate, because this was a question that was asked, posted prior to the webinar. Boutique winery generating less than 10,000 gallons per year would be exempt unless it's in an area that would have a high concentration of these boutique wineries, and the regional board would have a concern about groundwater impacts. So you're probably out of it unless you're in an area where there's a lot of fellow boutique wineries and there's a concern from the water board.
Mm-hmm. So your requirements are going to be specific based on which tier you fall under, right? So if you're exempt, you just have to have general practices to manage your processed water, which you should already be doing. And if you're in tier 1, you need to enroll for coverage under this WDR, but again, you don't have all the different water quality limitations, but you do still need to have good general practices to minimize runoff if you're irrigating, or minimize ponding of application of your processed water, and minimize nuisance conditions such as odors in your ponds. If you're in tier 2, it's those requirements of tier 1 plus monitoring of your source water, effluents, ponds and disposal, and solids monitoring. There's requirements for biochemical oxygen demand, BOD, and nitrogen loading rates. For subsurface disposal systems, you have effluent limitations for nitrogen, total suspended solids, and biochemical oxygen demand. Then if you're in tier 3, it's those requirements of tier 2, plus additional pond sizing requirements or liner requirements. And tier 4 is those requirements of tier 3 with the potential of groundwater monitoring and possibly semi-annual reporting in addition to the annual reporting. The exemptions for the groundwater monitoring would be under specific conditions and if approved by the regional board. One of those conditions is that the sum of the capacity of your pond system is less than 1 million gallons. And another component that's not listed on this slide here, but is kind of hidden in the WDR, is that those tier 3 and tier 4 facilities are required to have a spill and emergency response plan. So kind of talked about this a little bit, but the priority is going to be those wineries right now that do not have a WDR, and you have 3 years to file for coverage under the WDR. The process for doing so is completing a notice of intent to comply. That's your NOI, and that NOI includes a technical report to evaluate and identify your current conditions, identify what tier you fall under, which is based on the amount of processed water you're generating, how you apply that treated processed water, what your treatment system is, water quality information, and so forth. This does not mean you get to wait 3 years and then apply on the 3rd year. You need to have your notice of applicability approved really by January 2024. Now, if you are reviewing your current information and you identify that you are not currently in compliance with all the requirements in the WDR, as part of your technical report, you will prepare a compliance schedule to identify those discrepancies and what changes you'll need to be making. Things like, are you required to have a flow meter, and do you not currently have one? How soon will you be able to implement the flow meter? Let's say you are required to have lined ponds, but your ponds aren't lined. Your compliance schedule could be that, well, within 1 year, I will perform hydraulic conductivity testing to evaluate if I meet, in lieu of an actual liner, if I can meet the hydraulic conductivity standards. And if not, then within 3 years, I will update the pond to be able to meet those hydraulic conductivity standards or add an actual liner. This all needs to be included in this technical report with your notice of intent, and then the regional board will review that, and upon their approval, they'll issue the notice of applicability, right? So wineries without WDRs includes those that are currently covered under the Napa County Memorandum of Understanding, and are going to be the sort of higher priority from the state board and regional board's perspective to get enrolled under coverage. Next is going to be those wineries with WDRs, and they're going to be required to enroll when their existing WDR expires, or based on review from the regional board. And the regional board has sort of emphasized that they're going to be prioritizing those wineries based on the size of the winery and conditions of the WDR. They expect to enroll these facilities under the general order, if applicable, over the next 5 years. The third condition is new wineries, and new wineries are expected to be designed to comply with this general order within 100 days of starting operations. Now, a question was asked is, what if I'm a new winery now, but this general order is not yet implemented? Because we are still waiting on the fee schedule. And in that scenario, I suggest reaching out to the regional board to explain the situation. But it's my understanding that you would still need to be designed in order to, the winery needs to be designed to comply with the general order.
One other point on that new winery, this would not be for a transition in ownership. If an existing winery is being taken over, operations, or perhaps sold, that's not considered a new winery in the eyes of the state.
Yeah, thanks, Tim. That's a good reminder. It's a new winery is a true new facility.
Yeah.
So we have this timeline. Again, January was when the state board adopted the WDR. There was a workshop from the State Water Resources Control Board fee branch, which prepared different example fee schedules. I'll go over one of them here in a minute. They expect that the fee schedule will be adopted in July, this coming July, with enrollment to begin likely in August or September. And during this time, the state board and regional boards are going to be trying to transition wineries to file for coverage under this order. So this time now, the time to evaluate your site-specific conditions, identify which tier you fall under, and gather as much information as you can now about your system. What does your treatment mechanism look like? How much stormwater runoff is making its way to your treatment system or to your pond system? Where are you land applying it, whether it's for drip irrigation or for a subsurface disposal system, and any water quality information as well. So here's an example. I call it a potential fee schedule. This is one of the options that the fee branch presented during their stakeholder meeting. So you can see tier 1 facility, they're their fee would be $750, whereas a tier 4 facility generating more than 7 million gallons per year could be upwards of $19,000. And again, the adoption hearing for the fee schedule will be in July, and if approved, it's expected that they would be able to implement it sometime late summer. So when you come to apply, you'll complete the notice of intent. One of the key components of your notice of intent is this technical report. And in that technical report, you identify all the information about your facility, how much processed water you're generating, how are you disposing that processed water. If you have an irrigation system, what is the extent of that irrigation system? Are you meeting all the requirements for your tier? And if not, you have to develop a compliance schedule to be able to do that. Here's a sort of list of all the components that need to be in the technical report. There's sort of a template of the technical report in the order to provide some guidance. However, make no mistake, this is going to take a lot of time to be able to compile, especially if you have to try to read research to come up with these different components. There may be some of you on this call that don't currently have as-built or you know, that the as-built were never created. And so you have to go back and try to figure out retroactively the information about your treatment system and land application system. If you're a tier 1 facility, you really only need to complete these last 3 components of the technical report regarding your facility improvements and your proposed schedule to come into compliance with the order, summary information about your system, and then a certification. So next I'm going to go over the main land application systems. So we have processed water ponds that would then apply that treated water either for frost protection or irrigation or drip irrigation, and then we'll talk about subsurface disposal systems. So in general, for those of you who are land applying through irrigation, you need to irrigate in a manner to minimize ponding and allow sufficient dry time between events. And you cannot apply or irrigate within 24 hours of a forecast storm event with 50% chance of probability. So that means during the really during the winter season, you should be monitoring the weather forecast. And if there's a probability of a 50% chance of rain the next day, then you cannot be irrigating from your processed water ponds to the land application area. Similarly, the processed solids such as the pumice or sludge need to be applied in a manner to minimize nuisance conditions, and you have to prevent excessive nitrogen loading or biochemical oxygen demand loading. So for BOD, there's a rate of 100 pounds per acre per day. So you need to know the BOD concentration of what you are discharging to land. Regarding nitrogen, you have to perform a nitrogen balance with respect to the crop uptake. There are some references in the WDR to go over that, but that does involve doing a little bit of research on your water quality and the ability for nitrogen uptake through your crops. There's also requirements for setbacks. Setbacks may include like water cannot be discharged within 50 feet of a water supply or surface water. In line for those land application systems, you're going to have processed water ponds. The pond requirements are going to be based on your tier. So if you're a tier 1 facility, you can use the existing pond. The other facilities are going to have design criteria to be able to capture the 100-year 24-hour storm event, or possibly the 25-year 24-hour storm event with regional board's approval. Now, what this includes is incorporating the amount of rainfall that occurs directly onto the ponds. So in Napa, Sonoma, the 100-year 24-hour storm event is anywhere between about 9.5 to 12 inches of rainfall. So you need to incorporate that, plus any runoff that would be diverted to your pond system. So you're going to have to look at your process water conveyance and stormwater drainage and evaluate which drainage areas or sub-drainage areas are always diverted to my process water system, and does my pond have capacity for this additional volume. The ponds also need to be operated with a minimum freeboard 2 feet under normal conditions. So when we're talking about the alternative of a 25-year, 24-hour storm event, you have to incorporate that freeboard to demonstrate how you're going to manage stormwater in events larger than that 25-year, 24-hour storm event, including the 100-year, 24-hour storm event condition. Regarding your pond liners, if it's an existing pond in Tier 1 or Tier 2, the regional board may require that it becomes lined. If you're a new pond in Tier 2 or Tier 3 or Tier 4, then those ponds must be lined with leak testing every 5 years. Now that lining requirement may also include hydraulic conductivity testing, due to the nature of just these ponds, and for years and years and years that they've been operating, they may inherently have become sort of watertight over time. So you can perform hydraulic conductivity testing and be able to evaluate and demonstrate that the ponds meet the hydraulic conductivity requirements. Groundwater monitoring, again, would only be required for those Tier 4 facilities, but there is the exemption. That exemption really includes some different conditions. One of those conditions is that the sum of your pond capacity would be less than 1 million gallons total.
And that has to be approved by the local regional board.
That's right. It has the exemption would also need to be reviewed and approved by the regional board. Thanks, Tim. Jumping into the subsurface disposal systems, this includes things like an infiltration system or a leach field, drain field. The treated effluent would be discharged to a shallow disposal area. When you're completing your notice of intent and your technical report, you need to provide the specifications of the disposal system. You can't discharge the untreated processed water, and you can't have a commingled treatment system for domestic wastewater and processed water. So like the image below shows, you may have 2 separate treatment systems, one for processed water, one for domestic wastewater, discharging to the same leach field, but you can't have a commingled treatment system for domestic and processed wastewater. Now, there's some limitations for these subsurface disposal systems, including you need to provide sufficient dry time between applications. There's a hydraulic rate that you cannot exceed, and that's 1 gallon per square foot per day for the subsurface disposal systems. That's why you need to know the footprint of the leach field or drain field. The discharge must be applied in a way to prevent disturbance or compaction, and it cannot exceed the capacity of your leach field and generate surface runoff or discharge to a surface water or drainage course. And there's also water quality limits for total nitrogen, which has to be less than 10 milligrams per liter, biochemical oxygen demand less than 300 milligrams per liter, and total suspended solids less than 330 milligrams per liter.
And these are prior to application to land. These are these limits apply before the water actually discharges to the land. Correct me, Ron?
That's right. This is what's from the treatment system going to the leach field.
Yeah.
Here's a sort of summary of the monitoring and reporting program. So whether you're Tier 1 through 4, you're going to have the effluent monitoring, and Tier 2, 3, and 4 are going to have to do source water monitoring, pond monitoring if they have pond or land application, such as irrigation or using water for frost protection, monitoring of the subsurface disposal system, including effluent of the disposal area monitoring, and monitoring of the system itself, and then solids monitoring. And if you're in tier 4, you may have groundwater monitoring requirements, but like Tim mentioned, based on regional board approval, you may be exempt if you meet certain conditions. So here's another example of sort of land application area monitoring requirements based on your tier. So for instance, for flow, very first row, you monitor it such as by use of a flow meter in gallons per day. And if you're tier 3, you monitor on a daily basis, right? Or tier 2, 3, or 4, you monitor on a daily basis. If you're tier 2, you may be able to use an alternative method if you don't have a flow meter in place. You can demonstrate that you don't need a flow meter. For the reporting requirements, if you exceed one of those thresholds, such as for the subsurface disposal system, if nitrogen is greater than 10 milligrams per liter or BOD was greater than 300 milligrams per liter, then you have to develop a compliance letter summarizing the exceedance and the corrective actions moving forward. If you're tier 4, you may have a semi-annual report, and as that's if you are required to do the groundwater monitoring, then everyone's going to have an annual report. Now, if you exceed one of those thresholds, and we didn't talk about the fixes all solids threshold, but if you exceed some of the thresholds, you may have to prepare either a salt control plan or a nitrogen control plan. There's a threshold for fixed dissolved solids, which is basically your annual average fixed dissolved solids concentration from your source water plus 320 milligrams per liter. Right? So if you exceed that value when performing the monitoring, then you may be required to complete a salt control plan. For nitrogen, if you are in performing your nitrogen balance exceed the crop uptake, or if you have a subsurface disposal system and you exceed the 10 milligrams per liter, then you may be required to complete a nitrogen control plan. Now, for some facilities, you may be able to enroll in a regional salt and nutrient management plan in lieu of the salt control plan or nitrogen control plan. However, that's based on regional board approval. And again, I mentioned that these concentrations are all thresholds because they're not effluent limits. So if you exceed one of these thresholds, you have to perform some action. You have to complete the compliance letter. You have to do the right monitoring and implement corrective actions. But you could have violations, or enforcement can occur if you either don't implement the corrective actions or don't submit the compliance letter, like a report is not submitted, maybe your annual report is not submitted, or you submit the compliance letter, but then you don't follow through with the corrective actions, or you don't implement a salt control plan or a nitrogen control plan, and or the exceedances are such that they cause water quality impacts. And with that, I'll transition it over to John to review some of the legal aspects.
Thanks, Braun. Really appreciate you kind of going through those technical aspects. It can be sort of a daunting order from that aspect. As Buzz mentioned, I'm John Ugai. I'm an attorney here at Farella, Braun, and Martel, and we wanted to just take a few minutes to kind of talk about what the state board's legal authority is for the winery order, because that's going to both shape, one, the scope of the order and what sort of discharges it applies to, and also the enforcement risks that are result from the order. And so just kind of back up to give everybody an overview. The state water board and the regional water boards implement both state and federal water quality law. And so on the federal side, I'm sure a lot of you have heard of the Clean Water Act, which regulates point discharges to waters of the US. And you'll a lot of times see that through what's called an NPDES permit, National Pollutant Discharge Elimination System permit. And so that has its own requirements. And there are some slight differences between the Clean Water Act and the Port of Cologne Act, which is California's state law equivalent to the Federal Clean Water Act. They operate fairly similarly, but the Port of Cologne Act requires dischargers who may impact waters of the state to file a report of waste discharge with their local regional board, who will then issue facility-specific waste discharge requirements. But the Port of Cologne Act also allows the state or regional water boards to regulate discharges on a general basis for facilities that have similar operations or similar discharges. And so that's really what the winery order is. And we have a bunch of similar facilities, wineries that have similar discharges that are now going to be regulated with this general order that applies broadly across the industry. One of the key differences between state and federal law is that state law regulates impacts to both surface and groundwater, which is why we have this focus on land application, is because there could be potential impact to groundwater. And that's sort of a key distinction because there's really not the same level of regulation on the federal side. So if you go to the next slide, Mehran, please. And so that sort of helps us understand where the winery order fits into what is a pretty complicated water quality permitting regime. And it sometimes is difficult to understand because you're really dealing with both federal and state law implemented by a state agency. So it ends up being sort of convoluted. And so we thought it might be helpful just to take a step back and talk about where this fits into sort of what your current regulatory requirements would be as a winery. And it's important to note that compliance with the winery WDRs will only satisfy one of your permitting requirements. And so on the federal side, you're still going to have to comply with the Clean Water Act, which, as many of you are probably familiar with, includes the Industrial Stormwater General Permit. That regulates stormwater runoff from industrial activities. You might be familiar with it by having to compile an NOI and upload monitoring data to SMARTS and prepare a stormwater pollution prevention plan, or a SWIP. And so when you're doing that, you're really complying with the Industrial Stormwater General Permit. There's also a similar permit. It's the Construction General Permit that regulates stormwater runoff from construction sites. And so you may have had to deal with it if you're ever do work to improve your facility. It only applies to certain scales of construction, a certain size site. And so it's important to check with somebody like Mehran or Tim just to see if you need to do it if you're considering doing that type of work. The other kind of general permit to think about is that NPDES permit. And as I noted, it applies to point source discharges to waters of the US. What the key issue here is, because the winery order was adopted under state law authority, the WDRs issued by state board aren't actually an NPDES permit. So there might be some situations where you need to have both an NPDES permit and to comply with the winery order's WDRs. One such example would be like if maybe perhaps your wastewater treatment pond is very close to a river or a creek, so close that they're hydrologically connected. When you're adding processed water to your pond, you're actually impacting water quality in that river or creek. So that might be an issue where you would need an NPDES permit. So it's important to kind of, as you're going through the process of complying with the winery order and looking at your treatment process, to sort of think about, are there overlapping issues?
Hey, John, can I just add to that real quick?
Yeah, for sure.
So the difference there is that that your general industrial stormwater permit, I know many of our group members are on this call, specifically excludes processed wastewater. So you cannot discharge processed wastewater under the industrial general permit. But if there is a connection, say you have an unlined pond, there's a connection in your wastewater to a water of the US, you very well could need another NPDES permit. So.
Yeah, and I mean, that's a really good point, especially as you're thinking about like if you're sort of on the fence about having to line your pond or not, or thinking about requesting an exception to it, that could be a factor that you would consider.
Absolutely.
And so just something to sort of think about. And then you also have, although the winery order is adopted under state law authority, there are some state law permits that you might need. And in particular, the state board has an irrigated lands regulatory program that's implemented by the different regional boards. In Napa County and Sonoma County, under the SFA Regional Water Quality Control Board. It's the Napa River and Sonoma Creek Vineyard Program. And what it does is it regulates runoff from vineyards as well as sediment discharge. And so if you're in a situation where you're using your processed water to irrigate your vineyard, which is, great from a water conservation perspective, it's just something you want to consider because you may have to adapt your farm plan or make some changes to how you're complying with the irrigated lands regulatory program. One thing that's on the slide I just want to note, Mehran touched on this, but there is that 1985 memorandum of understanding between Napa County and the Regional Water Board that used to regulate sort of processed water discharges to surface. That's going to be phased out now with the new winery order. So as that's phased out, that will be something that you don't have to comply with anymore because you'll be now complying with the winery WDRs. Go to the next slide, please, Mehran. And so the last thing we just want to touch on are what are some of the enforcement risks that you might face. And again, this really turns back to the core thing that we've been talking about, which is that the winery order is adopted under state law. So we're going to look to the Port of Cologne Act and state law to see what the enforcement risks might be. And there are different than they would be under the Federal Clean Water Act. So the Port of Cologne Act really provides enforcement authority through the state water board and the regional water boards. And the main risks that you're looking at here are if you don't file for coverage, the state or regional water boards can ask the Attorney General's office to bring a lawsuit to get a court order that would require you to apply for coverage. And then a real risk is if the regional board orders you to apply for coverage and you fail to do so, you face both civil and criminal liability. So the state or regional water board could issue fines up to $1,000 a day for failure to comply. It also carries a charge of a misdemeanor. And then if they were to take you to court, Superior Court can impose fines up to $5,000 a day. And similar penalties also apply if you are falsifying information in your report, like that. So it's just important to sort of make sure everything is accurate, make sure if you receive something from the state or regional water board that you pay attention to it and look at it and figure out what you need to do to come into compliance. We had a question earlier in the chat about the local agency oversight program, which was a great question, especially because Napa County has previously been involved in sort of regulating these type of discharges. And the background to that is that the winery order allows local agencies to apply for oversight authorities to implement the winery order. The state and regional water boards will still maintain enforcement authority. What really this would kind of change who you're interfacing with. It's possible they can't disrupt what the floor is in terms of what the minimum requirements are of the winery order, but there could be additional requirements, fees. And so it's something to watch out for. To specifically answer the question, we're not aware of Napa County being approved yet. So it's our understanding that they're still in the consideration stage. But from a practical standpoint, the oversight, because of the detailed nature of the program, as Mehran just talked about, would put a lot of pressure and require a lot of resources from a local agency. So it's not something I think that they would take lightly if they were to apply for. And so I think that decreases the likelihood that they would want to do it. But we'll see. It's something we're definitely keeping an eye on and monitoring to see how it shakes out. The final piece are citizen suits. And so you may be familiar with these because the Federal Clean Water Act authorizes citizens or environmental groups to bring lawsuits to enforce the provisions and requirements of the Clean Water Act. But the Port of Cologne Act and state law doesn't have a similar citizen suit provision. So there's actually not the same risk of citizen suits to enforce the winery WDRs just because they don't have that cause of action under state law. And so you often see it with on the federal side with the industrial stormwater general permit. There are several environmental organizations in Sonoma and Napa County that have have brought lawsuits against wineries who are not in compliance with the industrial stormwater general permit. We think it's unlikely that we'll see sort of a similar industry pop up, but it is something to consider because, as we talked about, and as Tim mentioned, the issue with the process water ponds, or if you have a situation where you may need a Clean Water Act permit or an NPDES permit because your process water is being discharged or is the functional equivalent of a discharge into navigable water, that could provide a federal hook for a 60-day notice letter and a lawsuit in the Clean Water Act. So that's just another reason to sort of take a holistic view of your sort of process water system and identify those risks from the outset. So you can just make sure you're in compliance and avoid those type of situations. And as always, go ahead, Tim.
If I could just add, this is why the NGO community that have targeted wineries usually have a keen interest in the ponds. They're trying to find that connection between wastewater and processed wastewater and a navigable river so that they can extend their reach.
Yeah, and it has been sort of a murky area of regulation too. So it's, you know, in the past was difficult sometimes to show compliance and that you're in compliance. And so the winery order will help that in one sense, because you'll be able to point directly to the requirements and say, hey, you know, we actually have a flow meter. We keep records of these issues. In some situations, you'll have lined your ponds, which will be a great sort of thing you can point to. So there are some benefits on that side from the winery order in terms of reducing your risk, sort of if issues were to come up under the Clean Water Act, which is great. And so I'm going to turn it back over to Mehran because we're going to talk a little bit about different sort of compliance scenarios you may come under and what are some common strategies to try to evaluate your compliance strategy and formulate a plan.
John and Mehran, before we get into those scenarios, I just wanted to, I mean, one of the themes of this presentation obviously is to stay informed, and you've got a great group of folks here who are resources and other consultants too, and other law firms as well work in this field. But that's a key aspect of really what we're presenting on, is that necessity to stay informed. And I think also, as John talked about enforcement and you know, the legal aspects of compliance, I would say that, you know, generally speaking, and it's always a little bit dangerous to generalize, but generally speaking, when a program like the Winery Order is first rolled out, the Water Board is really more concerned with compliance. And so once you start to enter into that program, once you start to come up with a compliance plan, those are things that are protective from an enforcement perspective. And it's really, in our experience, only later, after the program's been rolled out, that you start seeing enforcement from any of the regional boards in this context. And just to put a finer point on it, let's say that time goes on and you have just, as an entity or a facility, you've just failed to do any of the notices of intent or anything along those lines, and time has gone past. There's going to be, at that point in time, months down the road, more of a focus on enforcement. But I would say, generally speaking, that right now the real focus is, from a regulatory perspective, is on compliance. So let's get into the scenarios a little bit at this point.
Awesome. And thanks, John and Buzz. And I do want to point out, if you are currently part of that Napa County program, the Memorandum of Understanding, which will be gradually transitioned as more wineries file for coverage, you're still required to comply with your Napa County program requirements, your monitoring and reporting, until you have the notice of applicability issued from the regional board and you phase out of that program. So I'll go over a few examples of scenarios you may fall under when applying for your notice of intent to comply with the WDR, and then we'll open it up for questions. So the first example scenario is you meet all the requirements in the WDR as it currently stands. For example, you might be a winery that generates 500,000 gallons of processed water per year. You meet all the requirements for a tier 3 facility. Your ponds are lined. You have a flow meter and totalizer to monitor the amount of processed water you're generating. the ponds satisfy the volume sizing requirements. So it's sized for your the amount of processed water that you're generating, your land application area meets the required setbacks, the ponds are lined, the water quality meets the thresholds. You complete the technical report and your notice of intent. You demonstrated that everything's good to go, and you file to the regional board, and the regional board reviews and then issues the notice of applicability, and then you continue to go forth with your required monitoring and reporting. I expect most of the wineries to fall under scenario 2 is you're required to comply with the order, but you still need to develop some sort of compliance schedule. You review your, as you're putting together the information for your notice of intent and technical report, you identify that there are some things that are required, but you're just not yet doing, or you need to make some changes for how you're doing it. One example might be you generate 500,000 gallons, so you fall under tier 3, but your ponds are not yet lined. In this situation, as you prepare your technical report, you would submit available information about your ponds, and maybe you commit to doing the hydraulic conductivity testing within the first year. And based on that hydraulic conductivity testing, if the ponds don't meet the conductivity requirements, then you commit to lining the ponds within 3 years of that. That would be one example just for the pond. There might be several wineries that have a laundry list of items that they would need to retrofit or modify in order to come into compliance with this program. Another pond example might be that you don't meet the sizing criteria, right? So the ponds must be sized to be able to capture the volume from the 100-year 24-hour storm event or the 25-year 24-hour storm event with regional board approval. There's different ways to approach that. One way is, well, it's a water balance, right? The amount of water that you have in your pond is a function of how much water is going into the pond volume, and then how much water is getting out of the pond, right? Where you're irrigating. Maybe you can increase the irrigation area with your treated process water, which would ultimately reduce the volume of water that's normally in the ponds, basically reduce your operational freeboard. You could possibly increase the size of the ponds, which sounds like a significant undertaking for most scenarios. Or maybe you need to augment the ponds with additional storage, either another pond or additional tanks to be able to capture the volume of the 100-year 24-hour storm event. When looking at the sizing requirements and considering stormwater runoff volumes, you want to look at both the volume of water that would be falling directly onto the pond, plus any runoff that would be captured and conveyed to your ponds as well. And this is going to vary depending on whether or not you have different diversion systems. You might have some sub-drainage areas that are always routed to drain to the ponds, maybe a tank farm that has drains that are always routed to go to the ponds. You need to incorporate that runoff volume. But if you have sub-drainage area that has a diversion valve where you can divert between your process water system and your stormwater discharge, then you need to evaluate, well, how much of the water is actually going to make its way to the ponds, and do I have a mechanism in place to divert, such as after the first flush goes to the ponds, and then I commit to diverting the rest of the water to my stormwater discharge. And again, if you have industrial stormwater discharges, you should have coverage under the industrial general permit. And then lastly, you might start evaluating these requirements and learn that you do not qualify for this general WDR. Maybe you're a huge winery and you generate more than 15 million gallons of processed water per year, or a couple other more common scenarios might be you have domestic wastewater and winery process water commingled into one treatment system. In a scenario like that, you could either separate the treatment systems, so you have one treatment system for domestic wastewater and a separate treatment system for your processed wastewater that then combine into either one leach field or two separate leach fields. If they do go into separate leach fields, you'd have a separate order and requirements for your domestic wastewater application. The other option, if this is infeasible to separate the two domestic wastewater treatment system and your process water treatment systems, then you could coordinate with the regional board to request the site-specific order. This would really be in a case that you have to demonstrate that it's just not possible to separate those two. Another example would be if you have distillation waste. If you're a distillery producing brandy, and that distillation waste is commingled with your winery wastewater, that is not covered under this general order. And in that scenario, you coordinate with the regional board to issue a site-specific WDR, or if you already have a WDR allowing that waste, then depending on whether or not that WDR is expired, coordinate with the regional board then to either update the WDR if it's expired. If it's not expired, then the regional boards would be reaching out to those wineries with existing WDRs, kind of based on their priority that they've established.
And I should add, you know, a site-specific WDR the water boards will be required to have an order that's protective of water quality. That's their mandate. Mm-hmm. So that you still may have some significant hurdles with an individual WDR.
Yeah. Thanks, Tim. So what you should do right now, between now and the time that the fee schedule is implemented and you can actually apply for this notice of intent, is figure out the volume of processed water that you generate annual basis, right? Identify which tier you fall under, and then implement go through your technical report and notice of intent criteria and identify, you know, what are my data gaps, and try to fill those data gaps. What do you know about your process water system, and how are you going to find out the remaining information that you do not yet know? Maybe you know, it's a subsurface disposal system and you don't have the as-built records. Can you figure out and any additional information about your current existing system so that you can file the technical report? Identify your treatment train, right? Things like just a rotary screen, which then goes to aeration ponds and so forth. If you have ponds, figure out the pond volumes. Identify which drainage areas will always drain to your ponds so that you could start to calculate the sizing requirements if they're applicable to you, the 100-year 24-hour storm event or 25-year 24-hour storm event. Identify your application area, where are you irrigating, and your subsurface disposal system details if you have a leach field or infiltration system. The next thing that you could do now is also stay informed. So the State Water Resources Control Board has an email list called LIRIS, and you can go to this web link here. We'll send out the slides later, and you can click on this web link and sign up. You could select water quality and then the statewide general WDRs for wineries. You'll get regular emails and updates from the state board. 2 days ago, through this LIRIS system, the state board put together sort of matrices of requirements based on each tier. So a lot of the requirements are spread out through the many pages of the WDR, and so you really have to read each page of the WDR and all the requirements to be able to figure out what your requirements are. So they kind of streamline this into a set of tables so that once you know your tier, you could go through that table for the tier and identify all your requirements and discharge limitations and so forth. And with that, I'll open it up to questions.